Hello, I'm David Bronskill, a partner with Goodmans LLP. On May 2nd, the Honourable Steve Clark, Minister of Municipal Affairs and Housing, introduced More Homes, More Choice, Ontario's Housing Supply Action Plan, and introduced Bill 108, an act to amend various statutes with respect to housing, other development, and various other matters. BUILD and the OHPA have produced a series of short videos to help the industry understand the impacts of the proposed changes on the market, practices, and businesses. This video will focus on the impacts of Bill 108 on the Local Planning Appeal Tribunal body and its processes. Some of the details of these changes will come forward in this legislation, others through regulations after Bill 108 has been passed, meaning we will focus on what we now know. Regulations will be particularly important on how the transition is handled. You will see that through the proposed changes that the province has kept LPAT, but is reinstituting a functional and efficient appeal process. These changes will focus LPAT on the planning merits of an application and not simply the decision of Municipal Council, which was the outcome of Bill 139, and will serve to speed decisions and approvals. A key change, and one that the industry has been advocating for, is for the return to de novo hearings. Essentially, the current post-Bill 139 two-stage hearing process kicks back decisions to local councils to reconsider their original decision. That has been replaced in favor of one hearing, where the LPAT once again has the authority to substitute its decision for that of Municipal Council. Also, like pre-Bill 139, the proposed changes will restore the ability to call evidence and cross-examine witnesses. A new change is that the tribunal will have the power to limit time for direct examination and cross-examination to promote more efficient hearings. Under the Bill 139 regime, mediation was entirely voluntary, with little incentive for parties to mediate. The LPAT could not require anyone to attend a mediation, and the two-stage hearing process acted as a disincentive to mediation. Under the proposed changes, there is a renewed importance of mediation in the planning system, including the ability for the tribunal to order mandatory mediation. Case management conferences are now required, with the tribunal given the jurisdiction to compel a party to attend mediation or another dispute resolution process. It's important to note that parties cannot be forced to agree to a result in mediation, but attendance at mediation can be compelled. Lastly, in an effort to expedite the process, the proposed changes will result in reduced timelines for municipalities to process applications and make decisions, after which an applicant can appeal to the tribunal for the failure of the municipality to make a decision within that shortened time frame. In addition, the government is committed to ensuring that the new LPAT is staffed and resourced appropriately to reduce the backlog. Of particular interest to the industry, particularly those members who may have a pending appeal in front of LPAT, there will be transition between Bill 139 LPAT and Bill 108 LPAT. As currently structured, the Attorney General has the power to enact transition regulations that will determine which Bill 139 appeals continue to be governed by the Bill 139 process and which appeals will be governed by the Bill 108 process. This may afford the opportunity for post-Bill 139 appellants to transfer an appeal into the new system. As Bill 108 works its way through the legislature and as the government turns to its attention to the supporting regulations, BUILD, OHPA, and of course Goodmans will continue to keep the industry informed of developments. On behalf of OHPA and BUILD, thank you for being a member and thank you for your continued support. If you are interested in learning more or have questions, please contact Paula Tenuta at ptenuta@buildgta.ca or me at dbronskill@goodmans.ca.